Hello, everyone, and welcome to the launch of our newest webinar series, Your Legal Compass, presented by Kelleher and Holland. The series is designed to help you navigate some of life's most important legal decisions with clarity and confidence, whether you're planning for the future, protecting your family, or preparing for the unexpected. Our topic today is Adrift Without a Plan, a look at what happens when you don't have powers of attorney or advance directives in place. We'll explore how a few simple documents can help you stay in control, avoid court involvement, and ensure that your wishes are honored. So we encourage you to ask any questions using the Q&A button in the Zoom control panel. And depending on time, we'll try to answer them live or we'll follow up with you via email directly after the presentation. So setting our course for the discussion today are three members of our team who focus on estate planning, estate and trust administration, and elder law. Joining us from our Naples, Florida office is Joanne Jeffries, along with Perry Smith and Laura Jelski from our North Barrington, Illinois office. And they all bring extensive experience in helping individuals and families chart a safe and thoughtful legal path forward. So Perry, start us off here and tell us why we should be thinking about planning.
First off, that you want to think about planning not only in these areas, but as far as with wills or trusts as well, all pretty much for the same reason. Number one, it gives you more control. You are selecting who you want to be in charge when you're not able to make your own decision, whether that is after your death for the will or trust, or during your lifetime, if anything should happen to you with regards to the power of attorney for either property or health care. You are selecting who you want to act as your agent. In other words, the person who would handle things for you. Now, there are differences from state to state in the laws on this. And that's why Joanne is with both Laura and I, because there are, as you're going to hear, obvious differences between Florida and Illinois, but that you can select not only who you want to act as your agent, but who you might want to act as a successor agent in case anything were to happen to the primary agent that you were to select before a necessity for the use of the power of attorney arises. You can also then give additional power beyond the statutory authority, such as for gifting, as well as making of trusts under the power of attorney for property, or you can restrict it by eliminating some of the statutory authorities. Similarly, with healthcare, you can give direction as far as whether or not your agent would have authority to consent to autopsy, consent to disposition of remains, give them direction on what your preferences would be if it is a situation where termination of life support might be an issue. And if you have particular individual thoughts, whether they are just based upon your philosophy of life or based upon a religious preference, you can restrict your agent's authority to consent to certain forms of medical treatment or medical procedures. Also, by having these in place, while it doesn't totally eliminate the need for a guardianship, it greatly minimizes the chances that a guardianship might be necessary. It could still be necessary if something is required over and above the authority you have granted in the power of attorney, or if the agent or agents you have selected are unable to act on your behalf for one reason or another.
So Laura, could you tell us a little bit about what could happen if you don't have proper planning in place?
So if you don't have proper powers of attorney in place, and as Perry was pointing out, obviously other documents as well, then the court's going to appoint who's going to receive your assets or who's going to be in charge of your assets. They will appoint a guardian who doesn't know your preferences or values through what's called a guardianship proceeding. The guardianship proceedings involve filing a petition, serving the disabled individual, and it requires a guardian ad litem to assess the individual's capacity to manage their personal or financial affairs. So they will determine the disabled person's financial needs and what then requires an annual budget. We'd have to go through an accounting and a care plan, and it would have to be then filed and approved by the court. If there's any changes in circumstances over time, then these changes always have to be approved by the court as well prior to being able to take that action. Now, that's obviously going to lead to a lot of stress, loved ones possibly arguing over financial or medical decisions. There'll be just delays in bill payments, delays in assets access, or medical consent on important procedures that need to be done. So at the end of the day, the state, not you, is going to decide on how your estate's distributed when you pass away and who's going to be making those decisions without having these proper documents in place.
Great. So Joanne, let's talk a little bit more specifically about these documents that are needed. And let's start with a power of attorney for property. And let's go into some key differences also between how they work in Florida versus Illinois.
Okay, thank you, Amy. So as Perry was saying, and Laura, what we want to avoid is court and conflict. And these documents are lifetime planning documents that really gives a client peace of mind. A power of attorney is a document where you, as the principal, will appoint an agent, a person to handle your affairs. So again, a powerful document giving somebody the legal authority to step in your shoes. And it's utilized during your lifetime. So hopefully, like an insurance policy, you'll never have to use that. But if you become incapacitated, if you're unable to make decisions for yourself, it is available so they can simply step into your shoes. And as Laura said, avoid court and conflict. Last thing that we want to have is families battling over who can be in charge or who can make those decisions for mom and dad. So it's a powerful tool for lifetime planning. In Florida, powers of attorney are unique. We no longer, once a person signs the power of attorney, it is effective legal document, as opposed to not being utilized or effective until you become incapacitated, which is known as a springing power of attorney, which I believe they have in Illinois, which Laura will talk about. But the document is effective upon signing. It needs to be signed in front of two witnesses and a notary. In some cases, a financial institution may have their own power of attorney or have some language that they would want included in that. People often ask, I have two children. Can I name more than one person as my power of attorney? And yes, you can in Florida. There's always the potential when more than one person is in charge for conflict. So sometimes we want to have another person to resolve any conflict among powers of attorney. Florida also has special provisions, especially for gifting assets and decisions that have to do with financial decision making. And these are called we call them Florida superpowers or special powers that have to do with gifting assets, changing beneficiary designations. So,
Laura, do you want to go into a little bit about Illinois and how it's different from Florida?
Yes, thanks, Amy. So Illinois does have its own statutory short form. It's widely accepted by financial institutions so long as it's meeting specific criteria. So it would include specific required language and it would have to be witnessed and notarized, which we provide for you. There's the importance, obviously, as Perry and Joanne had talked about, in naming not only your agent that you'd like to act for you if there was ever an accident or an illness, but also a successor to that person in case your first choice cannot act. In Illinois, you cannot name two agents on either your powers of attorney for property or healthcare. They do require you to only choose one person to act at a time. So making those decisions are important, and we obviously counsel you on making the right decision and what kind of choices they'll be making for you regarding specific powers like gifting or handling real estate if desired. The Illinois powers also can become effective immediately, or they can spring into effect, unlike Florida. So that means it could only be effective when you're mentally incapacitated due to an illness or an injury, or it could be effective immediately upon signing. And we obviously can talk about the benefits of these options more thoroughly in one-on-one conversations.
Great. So we talked about power of attorney for property. How does that differ from a power of attorney for healthcare?
Well, in the power of attorney for healthcare in Illinois, as Laura has said, you're only allowed to name a single agent. You can name multiple people, but they would be successor agents and they would act in whatever order you designate for them. This was a change that came in Illinois in about 2011. The reason being, it was very common that parents would come to see an estate planner. They would get a power of attorney, and they had more than one child. They didn't want to offend any child. They didn't want to show a preference of one over the other, and they would then name co-agents. Problem then became when you are in the termination of life situation. One child who's named as an agent says, "Mom would not want to live like this. Please terminate life support." The other child would say, "No, I can't be the executioner of my parent. I can't say terminate life support, keep the life support going." Well, they're of equal authority, and the doctors were caught because two people with equal authority are saying two different things. The same might apply to various forms of medical treatment, where two different people of equal authority were directing different forms of treatment. The providers, were stuck, and that's why Illinois law was changed to allow only one. Now, one of the things that you can do in your power of attorney for healthcare is that you can designate whether or not your agent is going to have some specific authorities. One authority is disposition of remains after your death, including whether that is for burial, cremation, or donation for scientific research or other purposes, as well as then whether or not to be able to consent to an autopsy. As I said before, you can limit the authority given to your agent by precluding them from consenting to certain medical procedures which you might not want to have. The example I usually give is I once did an estate plan for a gentleman who had converted to becoming a Jehovah's Witness. He was naming his sister, who was not a Jehovah's Witness, as his agent. Under his faith, blood donation or blood transfusion was precluded. And so we put a special clause in his power of attorney restricting his ability, or his sister's ability, I'm sorry, from consenting to blood transfusion, which would be in violation of his religious beliefs. Also, that you have a choice that coincides with the declaration for a living will, that you can designate what your choices or what your preferences are in termination of life support. Is the quality of your life more important than the length? Then you might want to sit there and say, if my doctor certifies that I am in a permanent state of unconsciousness or suffer an incurable or terminal condition, it is okay to terminate life support, similar to the living will. By the other token, if the length of your life is more important than the quality, you can designate, no, I want life support to be continued. Who knows what might happen? Who knows what medical treatments might be come up later, and something might be able to be done to bring me back. Also, one thing to think about with the power of attorney, as I just mentioned, we still have the living will. It's not a bad idea when you're doing the power of attorney for healthcare in Illinois to also do a living will declaration. That way, if anything is to occur so that your agent or successor agent is unable to act on your behalf, like you've designated your two children and the 3 or 4 of you are going out to dinner together in the same vehicle and are in the same motor vehicle accident and all severely injured, that you do have that additional document for the living will declaration, which will give direction to the physicians if you and your agent or successor agent are unable to do so. It's also a good idea periodically every 3 to 5 years to look at your documents again. Do they still do what you want them to do? Are the people that you designated as your agents still the people that you want to act on your behalf if you can't? And if any changes need to be made, go ahead and make them.
Joanne, anything to add?
Yes. So in Florida, we do it a little differently. We do a combined directive. So similar to the power of attorney for property that we just talked about, we appoint a healthcare representative. So we designate an agent to make medical decisions for us as a healthcare representative. Additionally, we combine that with instructions for end of life. So similar to what Perry said, in Florida, you can designate if you were in a permanent unconscious state at the end stages of an irreversible illness, disease, or condition, or unconscious, in a vegetative state, you can direct that you would want life-sustaining treatment withheld or withdrawn. So again, another powerful lifetime planning document to avoid court and conflict among your family members. You're appointing a person to make those healthcare decisions on your behalf if you're unable to make them, but you're also setting forth your wishes for end of life care. Additionally, in Florida, you can incorporate your wishes with regard to organ donation in that document. Some people will specify that on their driver's license. We always recommend that you give a copy of your advance directive for healthcare to your physician to make it a part of your medical records. And so these documents, as lifetime planning documents, we want to make sure that they're accessible to your family members in case of an emergency. If you're drifting off in that boat and something catastrophic happens, your agent knows where to find those documents in order to assist you.
All right, so my panelists have decades of experience preparing these types of documents. So we're going to answer a few commonly asked questions that they have heard come from clients. So let's start with this question, and hopefully we'll have some time at the end because I see a few questions coming in from our audience here live. What if somebody travels a lot or splits their time between states? Do they need a POA in both locations? We have a lot of snowbirds probably on the line listening, and I'm sure they would like to know the answer to this question.
In Illinois, the general rule is that if the document complies with the statutory requirements for the state that it was executed in, it will be honored here, even though it might not comply with Illinois law. Essentially, you're giving what in other areas of law is referred to as full faith and credit to the document, but it does have to comply with all of the requirements for the state that it was executed in.
Mhm. That being said, yeah, I generally recommend snowbirds if they're living in Florida for their 6 months and a day to have a good Florida durable power of attorney. Again, because our law is so different from Illinois and we do have those special powers, we want this document to be effective and to work during lifetime. So we recommend that you have a good durable power of attorney in the state where you're residing.
How about where you should keep your documents? What do you suggest is a safe place to store these?
We usually say keep your originals in a safe but still accessible location, like a fireproof home safe, or even with your attorney. We do have our clients have the ability to keep them in our vault where they can access them at any time, or have digital versions available where they can contact us and we can make sure it gets to the correct person upon giving us obviously proper proof that that is needed. Sometimes we suggest provide your agents with the documents. If you trust them and you want them to have access to knowing what they're able to do, you can provide them to your agent ahead of time. We usually do suggest that you at least tell your agent that they're going to be that person. So, in case of an emergency, they can reach out to us and get the document. I did see a question pop up about how do you keep control if your agent can act without your consent or knowledge. There's different ways that we can talk about how this can work given the specific situation, but I know when these situations arise, we usually say your agent doesn't necessarily need access to the document until they need it. So if it's with your attorney or with a bank consultant that you trust, then they can access it only if they show proof that you are incapacitated. We do say avoid safe deposit boxes unless the agent also has access. We have issues sometimes getting into the safe deposit boxes without obviously having the disabled person's consent. So that can be a problem because if they're in there and we need the power of attorney to use it to get in there, it creates an issue. And then, of course, your doctors. Making sure that your primary care physician has a set of your medical documents, and then if you are going into surgery or any type of medical emergency, bringing them in with you.
And how about updating your documents? How often should that be done?
We generally recommend that you take a look at your documents every 3 to 5 years, unless there's some important life situation that occurs. Or of course, you want to change your agents, your backup agents, or if someone dies. But every 3 to 5 years, or if you have a significant life event, I would be looking at my documents.
Okay, we do have time for a couple of questions that are coming in. Um, One question that came in is a family has multiple siblings, only one parent is alive and failing. One of the children has been appointed healthcare POA. Can a non-POA sibling contest the POA healthcare decision, thus halting the POA decision?
Uh, Probably not. They would have to bring a court proceeding to revoke the power of attorney, and they would have to show that in some way the agent under the power of attorney had breached a fiduciary duty or was not acting in the best interest of the principal, the person who gave the power of attorney.
And just important to add to that, keeping control of your agent is also a fiduciary. So it's their duty to act in the best interests of the principal. So any breach of that duty can also hold those people accountable. So for example, in a power of attorney, if your agent is acting beyond the scope of the power of attorney, or you're capable and they're acting without your consent or knowledge, they will be held accountable as a fiduciary.
Another question that came in is, do these POAs need to be filed with a county clerk? And if not, are the original documents valid if other family members contest?
No, they do not need to be filed in Illinois with a county clerk. Although many times that if it is a situation where the agent is acting on behalf of the principal with regards to the sale of properties and they are signing the documents, that sometimes not every time, but sometimes a copy of the power of attorney will be attached to the document to demonstrate that the person signing the document had the legal authority to do that. Any type of a contest of the power of attorney, though, it's valid until it is revoked by a court of law. If it is going to be contested or challenged, that a court case has to be opened and with a petition to revoke the power of attorney, stating what fiduciary duty has been breached and why the agent is not acting in the best interest of the principal. And then it would have to be up to the judge on whether there is proof of that in the entry of an order revoking the power of attorney.
I think just to add to that, speaking of revocation, as long as you're competent, you can sign a power of attorney or a healthcare directive, and you can revoke it. You can change your mind. Again, as long as you have the legal capacity to do that. Once you have a debilitating illness or advanced Alzheimer's disease or something where you're unable to sign a legal document, then you no longer have that ability. So that's when you will have to go to court to have somebody become your guardian.
And I
And
think
so
you just answered the next question there. Laura, did you want to jump in and add
I
anything?
did. I was going to add to that end, speaking of legal authority and when you have full capacity, now's kind of the time that your young adults, 18 and older, are going back to school, going to college. Now that they're over the age of 18, you no longer have the authority to make decisions about healthcare, about any financial accounts that they own. A lot of the universities and college campuses really want to see a power of attorney for property and healthcare for your children as well. So when they usually come up to you and say, Mom, can you call the doctor? Dad, can you put money in my bank account? Well, not unless there's really those powers of attorney in place. So preparing for back to school and going away for college is a good time to have your young adult advance directives set up for your children in which they'd be a part of putting together. And we have some resources on our website that we can send out as well about getting those started.
Great reminder. We had one more question come in about special needs trusts, but we're just about out of time, and that actually will most likely be a topic of a future webinar. We're going to talk all about that in detail. So you can tune in for our future webinars to get an answer of those questions. So thank you everyone for joining us today, and we hope that you found the information that we presented today helpful. And I am going to click through on some contact information for our speakers, so feel free to contact any of them directly for further guidance, and watch your inbox and our social media pages for details about our next webinar in this series. Or if there is something you would like to know more about, you can drop us a line at attorneys@kelleherholland.com.